Now we go global. And I know what some of you are thinking. This is the CIPP/US. Why are we talking about Europe? Because your clients don't operate in one country and the exam knows it. 5 areas. First, why cross-border transfers matter to American organizations at all. It's not an abstraction. It's your cloud provider, your support center, your analytics vendor. Second, the Schrems saga. Two Court of Justice decisions that demolished two transfer frameworks and reshaped global data flows. You need to understand why they happened because the reasoning still governs. Third, the mechanisms themselves. Standard contractual clauses, adequacy decisions, and the current EU-U.S. data privacy framework, along with the Swiss and UK extensions. Fourth, the newer direction. Restrictions on transfers to countries of concern and data localization requirements. This is transfer law running in reverse. And fifth, the conflicts, where US legal obligations collide with European ones. E-discovery versus GDPR is the classic case, and there's no clean answer. This chapter is where privacy becomes geopolitics. Let's go. Let me start by dismantling an assumption. Many American companies believe they don't transfer data internationally. Almost all of them are wrong. Think about your own organization for a moment. Where's your cloud hosted? Multiple regions probably. Where's your customer support at 3 a.m.? Manila maybe, or Bangalore? Where do your engineers sit? Distributed. Your analytics vendor, your CRM, your email platform. Each one is a potential border crossing. And here's the part that catches people. A transfer isn't just moving a file. Under European interpretation, if someone in India can access data sitting on a server in Frankfurt, that's a transfer. Remote access counts. So your offshore support engineer troubleshooting a European customer's ticket has just triggered transfer rules. I had a client, a mid-sized US software company, absolutely certain they had no European exposure. Then we mapped it. They had European customers. Their support team was in a third country. Their sub-processor list ran to 40 vendors. 3 of those had sub-processors of their own that nobody had ever asked about. Now, why does the law care? Because Europe treats data protection as a fundamental right. And a right that evaporates the moment data crosses a border isn't much of a right. So the rule is simple. Protection travels with the data. Which raises the question the rest of this chapter answers. How do you prove the protection traveled? Let me tell you about one Austrian law student who reshaped global data flows twice. Max Schrems filed a complaint about Facebook transferring his data to the United States. His argument was straightforward. Edward Snowden had just revealed mass surveillance programs. So how can US law provide essentially equivalent protection when American intelligence agencies can access data at scale and Europeans have no meaningful way to challenge it? In 2015, the Court of Justice agreed and invalidated safe harbor. 15 years of transfer arrangements gone overnight. So negotiators built Privacy Shield. Stronger commitments, an ombudsperson, more oversight. Schrems challenged that too. In 2020, Schrems too invalidated Privacy Shield on essentially the same reasoning. The surveillance authorities hadn't changed. The ombudsperson wasn't sufficiently independent. Europeans still had no real redress. But here's the part that mattered more. The court upheld standard contractual clauses while adding a condition. You cannot just sign SCCs and relax. You must assess whether the destination country's laws actually let you honor them. That's the transfer impact assessment. Think about what that means practically. A contract between two companies cannot bind a government's intelligence agency. So the burden landed on private parties to solve a public law problem. What's the lesson? Transfer frameworks built on political promises are fragile. The underlying surveillance law has to change. Let's look at the two workhorses of transfer compliance. Adequacy first, because it's the easy one. The European Commission examines a country's laws and decides whether they offer essentially equivalent protection. If yes, data flows freely, no extra paperwork. Japan has adequacy, the UK has it, Switzerland, Argentina, New Zealand, a handful of others. And notice what's missing. The United States does not have general adequacy. That's the whole problem this chapter exists to solve. So when there's no adequacy, you need a mechanism. Standard contractual clauses are the most common. These are pre-approved contract templates published by the Commission. You cannot rewrite them, you fill them in. And the 2021 modular version has 4 modules depending on whether you're controller to controller, controller to processor, processor to processor, or processor to controller. Here's what they actually do. They create contractual obligations mirroring GDPR protections. And critically, they give the data subject third-party beneficiary rights. So an individual in Germany can sue on a contract they never signed. And after Schrems 2, you also owe a transfer impact assessment plus supplementary measures where needed. Encryption, where you hold the keys. Pseudonymization. There are other tools. Binding corporate rules for intra-group transfers, though they take years to approve. Derogations for narrow cases. But SCCs are what you'll actually use. So after 2 invalidations, negotiators tried again, third time. The EU-U.S. data privacy framework arrived in 2023, backed by an adequacy decision. And this time, the US side did something different. An executive order addressing the actual complaints. It required signals intelligence to be necessary and proportionate, which is European language deliberately imported. And it created a redress mechanism with 2 layers. A civil liberties protection officer and then a data protection review court where Europeans can appeal. How does participation work? It's voluntary self-certification through the Department of Commerce. You commit to a set of principles: notice, choice, accountability for onward transfer, security, data integrity, access, recourse, and enforcement. You publicly declare your commitment. And here's the mechanism that gives it teeth. Once you self-certify publicly, breaking those promises is deception under FTC Act Section 5. So a European framework gets enforced by an American consumer protection agency. Elegant, honestly. Now, is it stable? Let me be candid. Schrems has said he'll challenge it. An executive order can be revoked by a future president more easily than a statute can be repealed. And the Data Protection Review Court's independence is contested. So what do I tell clients? Certify if it helps, but keep your SCCs current as a fallback. Don't build a single point of failure. Let's handle the 2 companions to the main framework because they trip people up. Switzerland isn't in the EU. It has its own law, the Revised Federal Act on Data Protection, the FADP, which came into force in 2023. It's GDPR adjacent but not identical. And Switzerland makes its own adequacy determinations independently. So there's a separate Swiss-U.S. data privacy framework, same architecture, separate certification. Switzerland recognized it in 2024. If you handle Swiss data, you must certify specifically for Switzerland. Certifying for the EU doesn't cover you. The UK is different again. After Brexit, the UK has UK GDPR and its own information commissioner. And rather than build a whole new framework, they created what's called the UK extension to the EU-U.S. DPF. So you certify for the EU framework first, then add the UK extension. It's a bolt-on, not a standalone. Here's the practical error I see constantly. A company certifies for the EU, ticks the box, and assumes it's done. Then a Swiss customer asks, and there's no coverage. Or a UK client's DPA asks for the extension, and it was never added. So my advice is boring but useful. Make a table. Which jurisdictions do you touch? Which certifications do you actually hold? Compare them annually. 3 frameworks, 3 separate acts of paperwork. Now let's flip the direction. So far, we've talked about Europe restricting outbound data. But the US has started doing the same thing for very different reasons. The concern isn't privacy in the European sense, it's national security. The worry is that bulk sensitive data about Americans in the hands of a foreign adversary enables espionage, blackmail, or profiling of officials. So there's now a Department of Justice rule following an executive order restricting certain transactions involving bulk US sensitive personal data with countries of concern. Categories include genomic data, biometric identifiers, precise geolocation, personal health, and financial data. Some transactions are prohibited outright, others are restricted, meaning permitted only with security requirements. Notice how different this is from GDPR logic. GDPR protects individual rights. This protects the state. Same mechanism, opposite philosophy. Data localization is the related idea. Store data here physically. Russia does it. China does it. India's DPDPA has provisions. And the rationale varies. Sometimes sovereignty, sometimes law enforcement access, sometimes economic protectionism dressed as privacy. Let me put the tension plainly. Every localization requirement fragments the internet a little more. A global company ends up running parallel infrastructure in a dozen countries. Is that better privacy or just more copies of your data in more places? Genuinely worth thinking about. So when does GDPR actually reach an American company? Because the answer is broader than most expect. Article 3 gives two hooks. First, establishment. If you have an establishment in the EU and process data in the context of its activities, you're in, regardless of where processing happens. Second, and this is the big one, targeting. If you offer goods or services to people in the EU or monitor their behavior, you're in, even with zero European presence. Now, what counts as offering? Not just having a website people can reach. Courts and the EDPB look for intent, pricing in euros, language options, EU-specific marketing, shipping options, mentions of European customers, and monitoring is broader still. Behavioral advertising, tracking European visitors counts. So if you're in scope, what do you owe? A lawful basis for every processing activity. Transparency notices. Data subject rights which overlap with state laws but include objection and restriction. Data protection by design. Records of processing, DPI. As for high-risk activities, breach notification within 72 hours, which is far tighter than most state laws. Possibly a DPO. Possibly an EU representative under Article 27. Here's the practical read I give clients. GDPR compliance is a superset. Build for GDPR and you've covered most state law requirements structurally, but don't assume the reverse. CCPA compliance does not get you GDPR compliance, not close. Let's compare these three regimes side by side because the differences are exam gold. Start with lawful basis. GDPR requires one of 6 for every processing activity. Consent, contract, legal obligation, vital interests, public task, legitimate interests. US state laws generally don't. You can process by default and the consumer opts out. That is a philosophical chasm. Europe says justify yourself. America says proceed until objected to. Second, consent. GDPR consent must be freely given, specific, informed, unambiguous, and affirmative. Pre-ticked boxes fail. Most US laws use opt-out for ordinary data and reserve opt-in for sensitive categories or minors. Third, sensitive data. GDPR calls it special category and generally prohibits processing unless an exception applies. State laws typically just require consent. Swiss FADP sits close to GDPR, but with quirks. It historically protected legal persons, not just individuals. Its breach notification standard is softer, tied to high risk. Fines target responsible individuals rather than companies, which is genuinely unusual. Here's the mental model I use. Europe is permission-based. America is objection-based. Switzerland is Europe with a different accent. Once you internalize that, the details stop being arbitrary and start being predictable. Now let's look at a genuine collision. Two legal systems, both binding, both pointing opposite directions. American litigation has discovery, broad discovery. A US court can order a party to produce essentially anything relevant, including data held abroad. Refuse, and you face sanctions. Adverse inference, contempt, default judgment. Meanwhile, GDPR says you need a lawful basis to process, and transferring personal data to a US court is a transfer requiring a mechanism. Some member states have blocking statutes that criminalize complying with foreign discovery orders. So picture the General Counsel's position. Comply with the US court and violate European law. Comply with European law and face US sanctions. There's no clean exit. How does this get managed? Article 48 says foreign court judgments are only recognizable through mutual legal assistance treaties. But MLAT is slow, sometimes years, and litigation doesn't wait. In practice, parties negotiate. Process data in Europe first. Filter for relevance locally. Pseudonymize, redact, produce the minimum, use protective orders, and use the Hague Evidence Convention where possible. I've watched teams spend months on exactly this dance. Nobody's happy, everyone's covered, roughly. The honest lesson? Some legal conflicts don't have solutions. They have management strategies. Let's close this chapter with the third approach to cross-border data, the one nobody talks about enough. APEC built a system called the Cross-Border Privacy Rules, the CBPR, and its philosophy is different from Europe's. Rather than assessing whether a country's laws are adequate, it certifies individual organizations. You get audited by an accountability agent, you get certified, you can receive data from other participants. Do you see the shift? Europe asks, is your country safe? APEC asks, is your company trustworthy? Country level versus entity level. And in 2022, it went beyond APEC. The global CBPR forum launched, decoupling it from the regional body so any jurisdiction can join. It's a genuine attempt at a third path between European rights maximalism and unrestricted flows. Is it working? Honestly, adoption has been modest. It lacks GDPR's gravitational pull. But here's why it matters conceptually. It shows that transfer regulation has multiple possible architectures. Adequacy, contracts, certification, consent. Each makes different trade-offs between rigor and workability. So how do you resolve conflicts in practice? Map your obligations. Find the strictest standard. Comply with that. Document your reasoning. And when there's a true conflict with no solution, document that too and get counsel involved early. That documentation may be your only defense.